All right, for more on what comes next, Fox News senior judicial analyst Judge Andrew Napolitano. Great to see you today.
I'm smiling because LaJeunesse got that Hawaii assignment, and we're here in snowy, freezing New York City.
We're taking this on the road right afterwards because we want to get people the most clear information. We want to be there. You and I have talked about this numerous times, and that ruling that came out from the federal judge in Virginia, she cited so many interviews of candidate Trump, appearances on O'Reilly, factoring the decision. So we knew even when they made over this order, those things weren't going to go away. So I want to read a little bit of what the Hawaii judge said, because a reasonable objective observer, enlightened by specific historical context, contemporaneous public statements, and specific sequence of events leading to its issuance would conclude that the executive order was issued with a purpose to disfavor a particular religion. In spite of its stated religiously neutral purpose, the court finds that plaintiffs are likely to succeed on the merits of their establishment clause. In Maryland, the one we got early this morning, it said the fact that the second executive order is facially neutral in terms of religion is not dispositive. So even though they made these changes to the text of it, these guys are still looking back at things that were publicly said.
All right, so all of that means that two federal judges, one in Baltimore, one in Honolulu, said that this was a Muslim ban by another name. They didn't use that phrase. I'm just trying to give folks a handle for it. That even though it didn't say it was a Muslim ban, and even though it denied that it was a Muslim ban, it was really a Muslim ban because it fell disproportionately on Muslims, and because of things the president said during the campaign and things that his colleagues have said, even here on Fox News, quoting Kellyanne Conway, Mayor Rudy Giuliani, and Stephen Miller. The problem with that method of interpreting something is it flies in the face of all standard interpretive tools that judges are to use. The executive order is very clear on its face. The president has examined classified data, revealed that which is not classified to justify his choice of these 6 countries to ban immigration for 90 days. Congress has given him the absolute authority to make these judgments, and he wrote it down and signed the executive order. End of the inquiry. To try and look for the contemporaneous context, the historical events, and the statements made by candidate Trump 6, 8, 10, in some cases 15 months ago is beyond the scope of what a judge should be doing.
Well, and I know that you think, in looking for, the Supreme Court hasn't applied this particular theory to these kinds of cases before. This is obviously a unique case of its own.
Right.
But they've looked behind things that are facially neutral before to see what was there, but not in this kind of case.
Because, great observation, Shannon, because this is an area in which the president is superior to the other 2 branches. It's foreign policy. And the Supreme Court has ruled that the Constitution gives the president primacy in foreign policy. He decides who our friends are, he decides who our enemies are, and Congress gives him the tools to effectuate those decisions. And one of those tools is the power to say, hey, you folks are not coming in for the next 90 days. You're not all bad, but there's enough bad people among you that we got to stop all of you until we can ferret the bad people out. That is absolutely rational and absolutely lawful, unless you are a federal judge who doesn't like the political outcome of this. Then you try to substitute your judgment for that of the president. That's the opposite of what federal judges are supposed to do.
Yeah, so this will go back through the Ninth Circuit, the one out of Hawaii. We know how they feel about this. They've already ruled against it. We'll see if their same reasoning applies to the second bite.
Don't you think that the Chief Justice of the United States should assign all these cases to one judge in one courtroom at one time, rather than having these fires being fought 10,000 miles from each other, Honolulu and Baltimore?
You know he may be the one who ends up hearing all this, because if we do have a split in these lower courts and the circuits, I mean, the White House, the president is vowing to take this all the way to the Supreme Court.
Right.
Whether they have 8 or 9 justices at that time, what do you think happens?
I don't know, because I believe it's a foregone conclusion that Judge Gorsuch will be Justice Gorsuch. I just don't know when. I don't know what the timing will be. Obviously, the administration would like that to be soon. Correct. And look, just because he gets on the court doesn't necessarily he's going to agree with the person who appointed him, but he is more likely than not to agree with an originalist version of this, a textualist version, meaning you read the words of the document, you don't try to psychoanalyze the author of the document. That's not the job of judges.
And we have seen Justices Sotomayor and Kagan rule against President Obama numerous times, so we know what happens.
Yes.
Judge, good to see you.
Oh, pleasure,
Thanks for coming in.
All the best.